if there is a delay in making an entry under exigent circumstances, does that delay now mean that the exigent circumstances is stale? My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training. I'm glad that you're here. So this question comes from an officer, not exactly sure where, doesn't really matter. The answer is going to be the same. So he says, is it possible for you to make a video on how courts respond and analyze exigent circumstances and exigent entries into a residence when there's some measurable delay in the entering? I commonly hear that if an officer calls their supervisor for a second opinion, return to their vehicle for breaching tools, or convene with other officers, that their justification for the exigent circumstances has been undermined, or maybe the better word is becomes stale. Okay, so what is exigent circumstances? Exigent circumstances is when an officer has objective reasons to believe that it's imperative to act now. In other words, what I like to say is, if you don't act now, will something bad happen? Will you lose evidence? Will the person escape? Will there be a danger to you or other people that are working the scene? So probably the best case on this is Brigham City versus Stuart. This is a U.S. Supreme Court case from 2006. Essentially what happened is the officers arrived at a loud party call. While on scene, they heard a loud disturbance coming from inside the residence, like as if somebody was about to fight. They went into the backyard to kind of check it out. And they saw through the sliding glass window, the door, that there was an altercation involving a very intoxicated young man, juvenile, and another adult. And the officers entered. They broke him up. They try to restore peace and order, and we go from there. Now, I'm not sure about what happened criminal-wise, but I do know is that Stuart said that the entry was unlawful because this wasn't legitimate exigent circumstances, and the U.S. Supreme Court rightfully disagreed. The point is that the officers had objective reason to believe that somebody would be hurt, whether now or in the immediate future, if they did not enter, restore that order. That's quintessential exigency and so forth. Now, that doesn't answer the question that's asked, though. What about a delay? Look, delays do not eliminate exigency as a matter of law. The question is, when you made the entry, did you still have exigent circumstances? I understand the devil's advocate where you can be like, well, if let's say you're a defense attorney, well, officer, you called your supervisor. That must mean you did not think you had exigent circumstances. I understand that. And that's, if I was a defense attorney, I would absolutely, try to argue that. But that doesn't mean you didn't have exigent circumstances. Remember, it's not what's in your head, right? As far as like subjectively, right? It's whether or not the law is in your favor. So was it objectively reasonable? In fact, I don't think it's unreasonable to, if you're a newer officer, especially a newer officer, to make sure that you're doing the right thing. Courts should not penalize officers on making sure and kind of like double checking their work. Getting breaching tools, that's obviously not going to eliminate exigency because you're going to probably need breaching tools to get into the house. You don't have to use the most inefficient method, right? You can use the most efficient method to enter the home. Having a meeting, kind of like a powwow with your cops on scene about who's doing what, who's on lethal, who's on less lethal, who's on breaching tools, who's going to be the OIC, whatever that is. That's fine too. So generally speaking, the way the courts kind of look at this is that if you had exigent circumstances initially, then you working that scene does not dispel the exigency as a matter of law. A great example is a barricaded subject. So if you have a person who's barricaded and you have exigency to do that surround and call out and to, basically, order them out and surround the home and so forth, and it takes, 4 hours to get that person out of the home. then they say, well, there was a law in this and you could have gotten a warrant about 2 hours into this. You guys are just sitting around. You guys knew that I wasn't coming out and you had plenty of people on scene. You could have sent somebody to go get the warrant. The courts do not require that, okay? I've never seen that before. I've never seen a court require officers mid-exigency, barricaded subject, whatever it is, to go get a warrant just because they had time to. The point is they're still working the scene. The courts still consider that there is exigency there, and you finish the job at hand. But I've also seen officers that will, if they do have time, they will go get a warrant. That's fine. I'm not telling you what to do. I'm just telling you it's likely not required. Okay? But maybe those officers are thinking, well, Anthony, we are not, we don't think this guy's going to come out, so we are going to do a hard breach. Okay, fine. Do you need it? Probably not. Should you get it? If you have time and you have the manpower, sure, it makes sense. I hope this helped you. Look, we have a lot of free webinars for our officers out there, for our prosecutors. We do them every single week, usually on Wednesday night. So go to bluetogold.com. Check out the free webinar schedule. They're about an hour long. We answer your questions. Every week is different. And, join hundreds of your fellow officers with us, okay? Again, it's awesome. You get a certificate. You can add it to your brag sheet, your training records, and so forth. Okay? Like, subscribe, share with your friends, and until next time, my friends, you stay safe.